Paul Kirumba.
Or he was released on bond.
So that we find out.
Was this just
14 days.
A232 of 2023, Feni Okwaro Owino versus the Republic.
Which prison? Who is the counsel for the appellant?
My lady, my name is Kimoso. Most obliged, my lord. Much obliged. Very well, my lady. Have a good day.
Good day too.
Your Honor, if I may, 19?
Yes.
I'm not sure whether the same has been attended.
John Chengo. Present. Lina Koskogi. Benjamin Ipkosgei. Benjamin Lorema. Benjamin Lorema.
Present.
Is there anybody here saying present?
Benjamin
Lorema.
Lorema. That is the 6th suspect.
So he's present online, eh? Okay.
Volker
Yes.
Odambo. Sifrin Robbie.
What have you said about Benjamin Lorima?
Sifrin Robbie. Sifrin Robbie. Mohammed Ali. Mohammed Ba.
Ms. Barasa. First of all, I wish to maybe for
Wait. So, Mr. Baraza, you are with me and Miss Gikui. Just a minute, and Miss Gikui.
Yes, my lady, Gikui.
Oh, okay. All right.
my lady, just with respect to during the last mention and I want to arrest to arrest because the court had his name has been called and it appears we are not sure whether those directions have been complied with. But we see a representation from the National Police Service. Maybe they will want to serve the court with some information.
Okay, I hear you, but let me just finish with the quorum. The parties that are present, we record.
My lady, we appear on behalf of the Director of Public Prosecutions.
Mr. Kabata.
Yes.
My name is Edward Mbani. Victims for the advocates. Representing Amnesty International.
You've mentioned your name.
wetu.
My lady, also for the Law Society of Kenya, we've been joined by Counsel Miriam Ouma, who's also present. Suspects to be produced before this honorable court, my lady. Therefore, the purpose of the mention is to confirm.
Is it a mention? What is it?
Yes, my lady. It's supposed to be a mention to confirm whether the warrant of arrest has been executed. Because one of the reasons why we could not proceed for plea, my lady, is because
I've read 2 rulings by Honorable Justice to be conversant with the matter fully. And the last ruling is, I'll just read out what it says, of 5th November 2024. In the result, I grant orders thus. 1. Plea taking is deferred to 15th January 2025 to be taken in open physical court. 2. The Inspector General of Police or a duly authorized officer shall appear in court to explain why the 11th suspect cannot be arrested. I'm assuming that's what you're alluding to.
yes, my lady.
And then 3, warrant of arrest issued for the 11th suspect to subsist. And 4, the 4th suspect to avail medical records to prove the fact of indisposition.
Yes, my lady.
Yeah, so we are on the same page. You can proceed
Most of
and address the court on that issue.
much. Might to appear. I'm not sure whether he has an explanation as to whether the IG.
Is the IG to appear? That's why I deliberately read the order as it is.
Yes.
Order 2. Can I read again?
Much of it.
The Inspector General of Police or a duly authorized officer shall appear in court to explain why the 11th suspect cannot be arrested.
Much of it. I'm told the representative is in court.
That's okay. We move on.
I swear by the name of the naked God that the information I'm going to give before this court, touching the matter in question, shall be the truth, the only truth, so help me God. I'm number. And with me, my lady, have a report that I will table and produce before this court. But before that, allow me to highlight that up to now, we have not been able to trace the 11th accused person. Namely Mr. Mohammed Ba Amin. Who retired as an assistant superintendent of police. In July, the year 2021. That complicates our effort to trace him. But we have seen made efforts. Having looked at his file, his service register indicated that he held Wajir County. In Northeastern. At a village called Madaga. Korwa sub-location. In Bataru location. When we received the order of this court and our warrant, with the information stated above, we forwarded the same to the regional police commander, Northeastern region, one namely Mr. Peter Ranka.
The second name, Mr. Peter who?
Pepita.
Oh, Pepita who?
Ranka. Who happened to be the author of the report I'm producing before this court. And he details the effect that their efforts go to the village and even to locate his parents and close relatives. We were informed by the area chief and the local villagers that the subject in question never went back to the village. And there was no trace of any parents or close relatives. We went further to another point of call. Where we contacted the National Association of Retired Police Officers. And we established the subject in question never registered as a member. Mr. Ranka also states that the subject home being close to the border there's the likelihood that the subject would have crossed over to the neighboring country. we will be coming before this court to seek for an extradition order if the subject is placed. Your Honor, allow me, before I finish and table the report, to state that the National Police Service derives the power of arrest or any effecting of a warrant that is in force from the Criminal Procedure Code. And Section 34 of the same Criminal Procedure Code allows for private arrest by private persons. So as a National Police Service, we are open that any citizen of goodwill if he traces the subject can report or either report to any nearest station or call any police officer. That's all my reading. With your permission, I can go to court.
You intend to serve the others, or we can deal with service later? Yeah. Okay. So that is with regard to the 11th accused person. So we are back to ODPP with regard to the rest of the matter.
Much obliged, my lady. In 2008, applying the Rome Statute domestically, My lady, it is the first time we are having a court, an international crimes bench convened. My lady, with the aim of bringing those responsible to account for very serious and high atrocity crimes. Section 7 of the International Crimes Act provides that the proceedings to be adopted, the applicable law, is the Rome Statute, my lady. My lady, since we are convened under the Rome Statute, Article 61 of the Rome Statute requires that the suspect be present in court. The trial is conducted in phases where we have the confirmation hearings before the pre-trial chamber, my lady. Here we are supposed to perform all those.
And so you notice I'm smiling.
Much obliged.
All that was canvassed and ably responded to.
I'm coming to
Wait, before we come to the application. That's why I'm smiling, because of us. But let us also ensure that the court does not act in vain. What the court cannot do, it can't do. Right? And that's why I started by saying I have read 2 rulings by Honorable Justice Kimondo, 2 rulings by Honorable Justice Mutende, and you and I are bound until there is a successful appeal. Keyword, successful. So as we conduct fair hearing, I'm supposed to hear you. Please have in mind what this court can do and not do. Just that.
Yes, my lady.
Yes, now you may proceed.
I hadn't made my application with and an application has been canvassed for international cooperation. With respect to the suspect, who is not before you today. To address the court on that issue, on our part, we do support that application for international cooperation, although we know Somalia is not a signatory to the Rome Statute. But based on bilateral engagements, we are hoping that any request for international assistance shall be acceded to. As you rightfully stated, my lady, made up our mind and we were ready to proceed. We have always been. However, Article 61 of the Rome Statute before the pre-trial chamber. And that's why we are saying this court has combined all those functions. My lady, this is not a normal penal code offense where you seek to hold someone accountable on account of his strict liability for what he or she has done or omitted to do. These are high atrocity crimes. Considered the most serious, my lady, because they affect the whole of humanity. My lady, the suspects are being sought to be held accountable jointly and severally under the doctrine of command responsibility or superior, under their role as superior commanders. Under the circumstances, therefore, my lady, and because Mr. Barr has not been produced the DPP, who is the equivalent of the prosecutor at The Hague, wish to humbly pray for an adjournment and more time. We shall be having meetings with IPOA, the Independent Policing Oversight Authority, that is, and to review the charges, my lord. Therefore, we will be humbly praying for an adjournment today and more time to redraft and amend the information, the charge sheet. My lord, the crimes are serious and very egregious, and therefore we will be praying for considerable time. If it pleases the court, 45 days, my lord. That will be all, my lady. Thank you.
Okay.
Yeah, ready? We are mindful of the powers delegated upon the Director of Public Prosecutions by the Constitution. Which are not subject to any direction or control, not even from suspects and including accused persons. Make decision on how best to proceed with a criminal case. For that reason, therefore, we'll be ready to avail ourselves as and when the Director of Public Prosecutions will have made his mind on the next course of action of this matter. That's all.
Kindly confirm that the defense.
Client, and we do not know the letter of amendment, so they can be granted the claim.
That issue was extensively deliberated on by your brother, Justice Kimondo, in his ruling. And he made it clear that the court of jurisdiction is the Kenyan High Court. And the procedure to govern that is the Kenyan procedures under the International Crimes Act. I also submit that the doctrine of stare decisis applies and binds this honorable court. Your Ladyship. On the issue of amendment of the charge sheet, on the issue of adjournment, Your Ladyship, for reason we've been told there's an intention to amend the charge sheet. We are not opposed to the amendment of the charge sheet. We are opposed to the time duration, 45 days. The alleged crimes that have been brought before this court, Your Ladyship, happened in 2017. And the victims have been waiting since 2017 for justice. It is our assertion that any further delay, leave alone 45 days, is not only denial of justice for the victims, but more trauma being inflicted on them. From the record we've been here for, this is the 4th time we've been here for plea taking. And it has not kicked off. And I think we've almost spent 2 years at this stage. So, Your Ladyship, we are suggesting a shorter time period, if that is possible. We are even willing to come in the afternoon if the DPP can have his house in order. Because what we've been told is an intention to amend the charge sheet. I don't see anything so technical that will require 45 days. Your Ladyship, also I hear that IPOA has been mentioned in that particular discussion. We have representatives from IPOA here who probably should also weigh in on that. That is all, Your Ladyship.
But lady, I had a suggestion. I could be wrong, but it's something to be made to be right.
Do I write or do I stop now so that we speak? It's a suggestion.
It's a suggestion.
Yes.
Yeah.
Go on.
Perhaps it would be a prudent course that we wait until after the plea has been taken and the proceedings have commenced in the manner known in criminal procedure. Then the representatives of the victims will have an open hand on what they may propose. Otherwise, we'll end up encumbering these proceedings with about 22 and more representatives of the victims without making substantial progress. That's just my humble suggestion.
I think, Senior Counsel, you've shown the way forward. How many lawyers are there, and you've ably led them.
Yes.
So I think the same translates to them. They are entitled. Remember, we are all supposed to ensure Article 50, fair hearing. So they have. So I think your method works. We can't have all of them taking the floor, but we can have one of them represent, and then if there's anything they feel that has been left out, you just add on.
That's perfect.
Okay. Okay. So Mr. Mbanya has spoken. Hold on, please. We have been moving in a very orderly fashion. Let's not change that, okay? So Mr. Mbanya has spoken. The victims' team has heard. If any one of them feels something has been left out, you can tell us.
Madam, with your kind permission, Chair Willis,
Yes.
I would urge the court to consider the plight of the victims and their numbers when it comes to their representation in these proceedings. Hence, when you see them seeking legal resources from across, all their voices ought to be heard, but you can always agree on a number. On the substantive application by the DPP, my lady, we strongly and vehemently oppose that application. And our opposition is supported by 3 rulings, in fact 1 judgment and 2 rulings by this court. The first judgment...
Just hold on, Counsel. So you object to the ODPP's submission?
Yes, ma'am. Justice Kanye Kimondo, when he made his first ruling, was very clear on the terms of that ruling. Plea be taken on a specified date. For good measure, that ruling, that part of the ruling has not been appealed. There has been no application set aside. That ruling has never been appealed. That part of the ruling has never been appealed. No application set aside. No order to vary it. So it exists. And it's binding on all of us on this side. The second ruling was made by your sister, Justice Lillian Mutende, in which at the time she noted the direction and the order of your brother Justice Kimondo. But out of abundance of caution and to accommodate the DPP, who had asked for 45 days. In fact, DPP was very emphatic. I need 45 days to apprehend the 11th suspect. 45 is all I need. She acceded and gave them 45 days. At the lapse of the 45 days, when again, and she directed the plea be taken, that ruling was not appealed, was not valid, was not set aside. Binding on all parties. When subsequently the plea was meant to be taken, again, at the instance of the DPP, speaking for the 11th suspect, they asked for more time to defer the plea. And she said, "You're trying me, but I'll give you one more chance." They were given one more chance. And they were told today, the 29th, in fact it was meant to be last week, on the 15th of January. She said the plea must be taken come rain, come shine. Rain didn't come, shine came. And today, it's raining. This plea has to be taken because it has rained, it has shined on both occasions. If the DPP was minded to amend the charge sheet, my lady, now let me go to their grounds. They were minded to amend the charge sheet because of the 11th accused person, suspect. Nothing would have stopped them from way back in October through the labyrinth of arguments before your sister Justice Mutenga. They had more than 4 months, cumulatively, more than 120 days to make this application, to amend this charge. They didn't. And my lady, the absence of a suspect in court, we were all taught in our first year criminal procedure that pleas can be taken and a person can be charged with others not before court. That was a cardinal teaching that we learned from our teachers. And many a times before this court, we've taken pleas with others not before court. And the plea has been recorded. So the argument about the presence of that party, those are not arguments for plea taking. These ones are here. Let them answer individually to the plea. Then if there be any argument on the procedure, how to proceed subsequent, that is for pre-trial before the trial court. That question will be considered if we can proceed. But on plea, even if they are all charged in the same charge sheet, they are all answering individually. There is no corporate plea of not guilty. 5 of them may decide to plead guilty. 6 may decide to plead not guilty. In respect to the 5 who may plead guilty, the court will proceed with the process as we know it. But those who will plead not guilty, they'll go through a trial. It shouldn't be open to parties for whom charges have been registered that a DPP who has registered the charges is the one saying I cannot proceed because one is missing. What precedent should we be setting in the Old Republic? On the question of application of the IC, the Rome Statute, my learned friend from the DPP was at pains to equalize this procedure, the pre-trial stage. The rules applicable in terms of plea taking and trials under the International Crimes Act are the criminal procedures of the Republic of Kenya. When it comes to plea taking, the criminal procedure of the Republic of Kenya applies. Otherwise, nothing would have stopped the legislature in enacting the ICA Act from setting up the pre-trial chamber and the trial chamber. We do not have it set up in statute. And the DPP should not, at this stage, try to re-establish the hierarchy of our courts. The hierarchy of our courts, as we know it, as captured in our Constitution, we only have the Supreme Court, Court of Appeal, High Court, Courts of Equal Status, and the Magistrates Court and tribunals. Nowhere in that entire hierarchy is there a division called the pre-trial chamber and the trial chamber and the appeal chamber. We don't have it. And these trials are being done in accordance with the laws of Kenya. My lady, I plead to this court to consider the plight of victims. Victims who have suffered for now more than 7 years, waiting for a day when they can come and tell their story and get justice. Article 159 of the Constitution talks about justice to be administered without delay. Justice to be administered without delay. Just on plea taking alone, this matter has taken 2 years before it is registered. Just on plea, guilty or not guilty, has taken no less than 2 years. Even if we were to compare now the parity of arms, these victims crying for justice vis-a-vis the suspects who are arraigned, and one of them is even a commissioner of police promoted subsequent to the atrocities. Are we being a country that is consciously aware of our Constitution and the need to accommodate all Kenyans? Even victims have...
Your Lordship, I think, to direct on one individual is unfair, because time and again, Mr. Willis has always directed that to my client. It's unfair. He hasn't taken plea.
I don't know who your client is, but I prefer in my court to remain issue-based. I don't like dealing with personalities. If we are to refer to a personality, let that personality also be in court and be given a chance to be heard. So let us focus on the issue. I welcome issues. Personalities, we also must allow them to be heard. So I'll delete the last statement. I didn't hear it. Then continue with the issue. The issue is the victim's rights, as I understand it. So let's hear that.
The victims, it is after my train of thought that I'm coming back to it.
Take your time, take your time.
The victims.
And my lady, perhaps you could ask coming Deputy President of the Republic.
The signet.
Don't speak so loudly.
Gentlemen,
Because,
as you aspire for higher office, can we remain in this legal forum with the law? We wish you well. But let us remain in this forum. This one, it's only the law.
We'll stay to the law.
Yes. You were saying something, Mr. Harvey. You stood up.
My ears have a big problem, so it's speaking very loudly.
Okay, okay.
Normally, of course, people ask themselves to speak louder, but for the first time, I'm told.
Gentlemen, can we focus? Let us focus. We were at victims' rights. So let us follow that. Let's follow through.
The victims have waited to just make a cameo appearance in court for 2 years to listen to plea taking. Only 2 years, just on plea only. While the country moves on, the victims, some of them, are lying 6 feet under. Their distraught families are asking the question, where is justice for us? And I invite the Honorable Court, in making the ruling on an application by the DPP to adjourn, to consider what is the responsibility of state institutions, and in particular the DPP, to facilitate expeditious disposal of disputes, and what is his role in regard to the victims of crimes. Because as it is, all the adjournments, all the plea deferment that has taken place subsequent to Justice Kimondo's ruling have been at the instigation of the DPP, and only on a singular issue. The 11th suspect is at large. I would expect a diligent director of public prosecution to say
delete. We've just said personalities out.
Okay, I'm talking of the office of director of public prosecution.
Move on to the issue.
The DPP, as a state institution, has a duty to all Kenyans to ensure that justice is meted in every case that it registers. It cannot be that in some cases, in our, as I conclude, if for nothing else, this court should invite the DPP's office to make that application at pre-trial, not at plea. If they come with an amended charge sheet tomorrow, they will take plea on the amended charge sheet. It doesn't stop anything. There is no prejudice. But for today, I urge this court to abide by the decisions of your brother, Justice Kimondo, and your sister, Justice Lilian Mutende, that the suspects who are present today in court take plea. And subsequent to that, all these arguments can come at pre-trial. Thank you very much, my lady.
My lady, a court of law is a court of records. And my lady, the feeling that we have today is a feeling of deja vu. The reason I'm saying this, my lady, is that this similar application was made by the DPP on the 5th of November 2025. 2024, sorry, my lady. My lady, I appreciate the fact that you've taken time to go through the ruling. And the ruling will bear record, my lady. That the only reason...
Which one do you want us to look at?
The one for 5th November.
5th November?
Yes, my lady.
Yes.
My lady, the only reason why the plea was deferred on 5th of November 2024 was the fact that the fourth accused was absent. That was the only reason. And she was absent on medical grounds. So presuming that the fourth accused was present on that particular day, plea ought to have been taken. My lady, we fully associate ourselves with the submissions by Council Willis Ochin. And perhaps, my lady, will only highlight that this is a matter of significant and great public importance. My lady, the DPP exercises their constitutional powers under Article 157 of the Constitution. But in exercise of these powers, my lady, under Article 157, sub-article 11, it says that in exercise of these powers by this article, the DPP shall have regard to the public interest, the interest of administration of justice, and the need to prevent and avoid abuse of the legal processes. My lady, our submission before you today is that their application for adjournment today is in disregard to this particular subsection. Further, my lady, Section 4D of the ODPP Act enjoins the DPP to act in a manner that promotes public confidence. Again, my lady, the application for adjournment for the fourth time in a row for the same reason does not promote public confidence. My lady, I invite the court to look at the guidelines for active management in criminal cases, which urges the court to deal with this matter in an expedient way. And that is at 1.2, where the court in dealing in criminal matters should determine a case in an efficiently and expeditiously.
You said that we look at
the
criminal
guidelines for active case management in criminal cases.
Guidelines
For active management of criminal cases in the magistrates and the High Court of Kenya. My lady,
can I leave the responsibility? You give us a physical copy through the DR so that you're sure I have read it. Thank you. So do that. Go on.
My lady, countless authorities from this very court, the High Court, have held that inasmuch as Article 157 grants the DPP the power to prosecute, my lady, these prosecutorial powers in the new dispensation did not grant the DPP a carte blanche to run amok in the exercise of the prosecutorial powers. That has been held in countless authorities. And that is why the High Court has been enjoined to supervise the exercise of the said powers. So in as much as we appreciate that they do have the powers to prosecute and or stop criminal proceedings, that this honorable court ought to intervene where it deems
that the exercise of that power is not in accordance with the law, the rights of the victims, as enshrined under Section 4 and Section 9 of the Victim Protection Act, as well as the Constitution, which is the Supreme Law. In conclusion, Your Honor, is our submission before you today that 10 of the 11 are before you today. Let us immediately proceed with the plea taking. That will be all, Your Honor. I think there was counsel online.
Anything new?
Yes, in so much.
Anything new? Don't mention the ODPP Act.
Be traced. They have also admitted that Somalia is not a signatory and it might be impossible, if not difficult, to extradite the accused from Somalia.
To allow that application for amendment, then the court also directs that the director himself, the office bearer, comes to court to explain. The reason why we are saying this is, as the hunter learned to shoot without missing, so did the bird learn to fly without
That's
patching.
a mouthful. I can't get that. Tell me.
What I'm trying
Simple
to say-
language,
what
just
I'm
tell
trying-
me.
What I'm trying to say is that we are seeing a pattern where this matter is not taking off. So if that then would be the trend, then it would be important to find out from the director himself what is happening, if at all, the application for amendment were to be entertained. Although,
So your instructions,
yes, like for the fourth time,
your instructions from LSK chair
yes,
are that, now continue.
that if the courts were minded to allow that application, then it will be important to personally have the director appear in court to explain on the fourth time why the matter is not taking off my name. One very crucial thing that the court should remember, even as the law on amendment of charges is a settled area of law, is that this year, my lady, Baby Pendo will have been 10 years old. And even though the dead never run out of time, the living must always jealously guard the time they do not have. The family is looking at the court, and the 49th president of the Law Society reminds me that the DPP is like your mother-in-law. You never want to antagonize your mother-in-law, but I'm finding myself in a very curious environment where defense counsel and the prosecution they're supposed to be jilted lovers, not lovers actually, so that they're not supposed to agree in simple terms. In most jurisdictions, they sit on opposite sides. Time is what we do not have, Your Honor. On the fourth time, a driver of prosecution is saying, and a very good friend senior there is saying, that we adjourn, we take more time to amend. But we are saying that even in the afternoon, if this were to be allowed, the suspects are here in court today, not in the number that they expected them to be, but we can still attend to the plea taking that has severally been directed and ordered by your siblings, both Justice Kaniki Mondo and Justice Lilian Otembe. And just off the record, perhaps, my lady, if we could conduct the afternoon session as you direct in a different court where we can all sit down, I will try. I have a bad leg.
Oh, apologies. We don't have enough space for all of you.
Right. the president will say it's my weight, but it's not.
Okay, we'll take that. We'll ask the court administrator to look into that.
Yes.
I thought you just wanted to stand. Now you brought it to my attention. We'll do that next time.
Yes.
Right.
We could come in
And that I've not recorded.
Yes.
Those are logistics.
We could come in the afternoon for further directions as to that amendment, but we are ready to proceed.
My lady.
Okay.
It is not proper. My traditions do not allow me to do this.
Gentlemen,
Those
those are housekeeping issues. I'll leave them to you. I'm on this side now. Are we through? We've had the victims team. We've had the LSK.
Being the agency that conducted this investigation, we are keenly aware of the suffering of the victims in this case and the impact, my lady, the delay in this matter is having, my lady, on the victims. My lady, on our part, my lady, we are keenly eager, my lady, if plea would proceed today, my lady. My lady, and if this court is minded, my lady, to allow the application by the DPP, my lady, we have our investigating officers here in court, my lady. We can canvass with the DPP as is suggested today, my lady. And the DPP can come up with amended charge sheet. And we take plea in the afternoon.
So you have the investigation officers in court,
Yes,
eh?
my lady, they are in court. As suggested by the DPP, if he wishes to canvass with the investigating officers, they can canvass, my lady, this morning. The DPP can amend the charge sheet as he so wishes, my lady. And plea can proceed, my lady, in the afternoon. My lady, we do feel the heavy weight that delay in this matter is causing to the victims. And my lady, we urge you, my lady, in making your determination to consider that aspect and our readiness, my lady, and willingness to cooperate with the DPP to ensure plea proceeds today, my lady. Thank you.
Thank you, most obliged, my lady. I will be responding to the submissions which have been made by counsel for the victims and also by the counsel for IPO. I'm not sure whether he's counsel or an investigator in his capacity, because I would be worried if he's an investigator investigating and also addressing you at the same time. Because we want investigators to be out there in the field investigating and not coming here in court to do what we prosecutors are supposed to do. So we liaise with IPOA, we give them directions to investigate, but we don't invite them here in court to come and help us to prosecute our case. So his suggestion that we can sit down and in 2 minutes give him directions on what we want to do, my lord, that's a fallacy. Because sometimes we require the investigator to travel to Kisumu and talk to victims there, cover some areas. So it is not as simple as counsel is suggesting. And therefore I would humbly request that they send investigators to boardrooms and leave the work of prosecution to the Director of Public Prosecution. Investigators and prosecutors should not be prosecuting the matter at the same time.
Council, you notice I'm not writing.
Much obliged.
That is a loud message
Most
that we don't need to go down that line.
Much obliged.
Yeah, with respect.
Most obliged.
Today it is this case. Tomorrow you'll still work together.
Yes,
so
and
all you
that's
have said I have heard,
Much obliged.
but I have chosen not to record. It will not go on record because the law states.
And it symbolizes, we concede the trauma the victims have suffered. But in the cold and the gloom, my lady, we must find the silver lining. Even in the darkness and gloom, we must find the silver lining and give hope to the victims. Not despair. We are here to seek justice, not to fight. We are being told of a hunter who learned to shoot without missing because the bird learned to fly without perching. That's the correct proverb. But we are not here to fight each other. We all belong to the bar, and the LSK president is also our president. Therefore, my lord, just to respond to a few issues, we cannot predetermine that the suspects are all guilty. To quote your brother judge, that it is better to even allow 10 men to go scot-free than to incarcerate wrongfully an innocent suspect. It is good to expedite justice, but we have to ensure procedural safeguards are in place. My lady, your brother judge never directed us to prosecute. He simply placed the matter for mention so that other processes can go on. The jurisdiction under Article 157 cannot be exercised under direction of anyone. And therefore, it is a lie that we were directed. There was no such order, my lady. Justice Kimondo never made that order that we must take plea. And neither did Honorable Lady Justice Mupende. That was a judicial review case in which the decision to charge had been challenged.
Well, I believe it's a court of record, and the rulings will speak for themselves.
Yes, that's why I'm going through the record, because I'm the only one who is new to this matter. All of you are telling me everything. So as I write, I need to look at the file and see what my colleagues in dealing with the matter had indicated. So bear with me. Okay, you may proceed.
Yes, my lord. That was a judicial review application. Which was dismissed. And therefore, as ODPP, we did not need to appeal against Honorable Justice Kimondo's decision, because that case sought to interfere with our constitutional mandate. And therefore the application was dismissed, paving way for this case. So this case has nothing to do with such orders that were issued before other courts. This is a new court exercising its own jurisdiction. It's not bound by orders of a different judge. There were no orders on this court that these matters should proceed in a certain direction. So that is a lie, my lady. We didn't have any such order. The court simply said, let the matter be placed before this court for these processes to take place. My lady, I wish to respond to another issue that a plea can simply take off, because even if one suspect is not present, the others can proceed. Yes, we do concede that can happen, but it also depends on the nature of the case. Not all cases can proceed in the manner in which counsel is suggesting. The Rome Statute and Section 4 clearly states the procedure to be followed.
Section 4 of the International
Crimes Act.
Okay.
Section 7 also clearly states that proceedings and the law applicable is the international, the Rome Statute and the the proceedings at the International Criminal Court as applicable before the International Criminal Court. Finally, Your Lordship, you are informed that we have admitted that the suspect cannot be found. We did not make any such admission. It is the police that have placed before you material showing that the suspect cannot be found. But we did not admit because we don't conduct investigations. And that's why we say that we support the application for international cooperation to seek assistance from an international state party. None of the counsel for the victims has indicated whether they support that or not. My lady, circumstances have changed due to that report by the National Police Service. we don't need to review the entire case, but because of the circumstances, we need to look at the modes of liability for each suspect and how proceeding without one of them will affect the others. And therefore, that's why we are seeking for more time to review the information. We all agree that victims need justice, but justice is not pegged at the conviction of an accused person. The court has wide powers, and counsel representing the victims are aware about that. The right to reparation and the right to other remedies is not restricted to having an accused person convicted. And therefore, proceeding on the premise that the delay of a criminal case will prejudice the right of the victim to justice, my lady, that is not the correct position. The wheels of justice are rolling, and therefore, if this application is granted, rights of the victims shall not be prejudiced. We will humbly be praying that we be given more time. And the LSK president is welcome to our office anytime, my lady. Or any other Kenyan seeking information from our office, anytime our doors are open. A court order is not necessary for the president to come.
Are you sure you want to go down that line?
My lady, they opened that door.
No. You see, if you can agree out there, that's fine. We have no problem.
I hope you will come for a cup of tea.
That's okay. That's okay. In fact, that's the way it should be. But I don't think I'll write that.
I'm just a vice president. I'm not the president. There are lessons that
Gentlemen, let's focus. Yes.
My lady, we humbly pray. We, under Article 157, we act in the interest of the Republic. We are mindful of the rights of the suspects as well as the victims. We are humbly praying that we be given more time, my lady, to review the investigation files. And we shall be having long sessions with our brothers from my board, not 30 minutes, we need a lot of time. That's all, my lady.
My lady, before it's lost on the court,
Wait. You say you are mindful of the rights of victims, eh?
Yes, my lady. As well as the rights of the suspects.
And suspects?
Yes.
And you are aware of the Article 157?
Sub-Article 11, which enjoins us to act in public interest. Public interest is not always what a party wants. It is what is good in the administration of justice, my lord.
Okay. So I think I'll end there. Yes.
There's a point that my colleague from the DPP did not mentioned to the court. I just wanted the paragraphs to be on record.
Which paragraphs?
Because he says that the court did not direct.
Please,
Yes,
please,
that's
please.
what
Wait. Allow me. The decisions of the court are in the public domain. They are on EKLR, right? The portal where anyone can log in and read. This record is a public record. You can go to the DR and ask to peruse. And I have told you, I have not read the whole file. In fact, from your submissions, I've had more than I knew of the matter. But I skimmed through and I saw there were 2 decisions by Honorable Justice Kimondo, there were 2 decisions by Honorable Justice Mutende, and there was the inquest that was conducted and concluded in Kisumu. Yes. At least those 5 I can confirm. Now, if we get into let us read paragraph this, I want to be satisfied that all of us have what I have. But if we keep saying, and you said this, then I said this, we will lose. No, he does. Trust me. I know what you want to read. I know you want to read paragraph 63, and you will not read it. I know. I know. Trust me. Trust me. Yes. No. If we go down that line, wait, Mr. Kabak, please. If we go down that line, how come I've just told you what the paragraph is? Yeah. So I want. First, if anybody is saying you do not have those rulings, I'm ready to allow that you can peruse the court file before the DR and get copies of the rulings. They are written in English. We'll all read them. So let us not go back and forth saying, no, the ODPP did not look at this. I am happy that we have the rulings, all of us. Anyone who does not have and would like to, this file will be available with the DR. And I know what was said in those rulings. Can we leave it at that, please? Thank you.
My lady, I just had one thing, just a few things to say, which need not be written, but...
Okay. Off the record.
Yes. My lady, I agonized a lot to accept this brief. For these reasons. There has to be justice for the dependent and any other victim subject matter of this intended prosecution. But in the pursuit of retribution against these 11 who have been brought to court, that fundamental obligation that we can as well release 10 people in respect of whom we have doubt, that convict one person who is innocent, the one that compelled me to come to this court. There must be justice for the dependent and the rest of the victims. But we cannot at any one point in time subject these 11 or the 10 who are here to what we have said was wrong to the victims. Mob justice. That's my plea. And just a minute, please.
This sounds like a
I'm not writing.
Yes.
We finished with ODPP. Yes. We finished. So he just says he has something to say. If you are unhappy to hear what he has to say, nobody is told to stay here. This is a discussion. No.
The mind of the court is active and the court is listening.
Let me assure you, as you have always told us, you always tell us that we must comply with Article 50. That is the only article that I'm thinking of. And you know, A, B, C, D, you know all that. So if it is the mind of the court, you'll also be given the opportunity to make sure that the mind of the court is not interfered with. Yes, so that's why I'm not writing. We have ended the official part with submissions by the ODPP. And I have made sure that each team has been represented in these proceedings. All right? Okay, so finish your submission, and then I can just give directions on what I want to say about this matter.
So, my lady, this is what I wanted to conclude with. The DPP has said he wants 45 days. Ideally, the request for time for purposes of enabling the DPP make a decision to inform the progress of this matter is not objected to. What appears to be the case is the amount of time. And speaking for the intended accused person, and I will say this, because justice sometimes requires you put the law aside. If the DPP was to come and say, 2 of these people need not stand trial, 3 need not stand trial, we will have done a good thing to the person of justice.
Now, if you go down that line, then this discussion will be over, because again, the law requires that what the ODPP does and the charges they prefer and who they bring, the court accepts, and
we, as the representatives of the accused persons, want to see what it is that the DPP wants to do. So the question that the court asked is just a matter of time. How much time is it that can be given to it? That's all that I'm asking. Because as we said, we were here, ready, willing, and able.
But then on the suggestions, ma'am, this is a suggestion, just to respond to this suggestion. The danger that we run is when we start making suggestions on administrative running of this case, is that we'll be taking precious judicial time, discussing suggestions which parties should be discussing outside the courtroom. So I will urge the court that at this point, we leave it to the court. We've made our submissions on the substance of the application. If there be any further suggestions, have you as a former president and me as the incoming deputy, we can convene all the other councils and we have tea and discuss those administrative suggestions, but we don't hoard what we are now doing. The other Kenyans looking for justice cannot access the learned judge because we are making suggestions in open court. I urge my leader that we close the
okay,
process.
now wind up. All right. So we have come to the end of the submissions, and I just want to make 2 points. I would request, therefore, humbly, that you allow me to retire, go through what the able submissions that have been made by all teams, and the file again if I missed out anything, and then tomorrow in the afternoon at about 3, I think I'll be able to deliver what I think would be the directions in the matter. Thank you very much.
Thank you so much.
Is an advocate by Paul.
Who is Festus? I have a Mr. Kinoti. Maybe you know him by first name, but what I have on record is Mr. Kinoti of IPOA.
My lady, I don't think that is in doubt.
No. So I don't know who is Festus. It's you.
It is me, my lady.
Okay.
Yes.
All right.
I think council was just trying to clarify, he's not an investigator, he's an advocate.
Okay, fair enough.
But then it is our understanding will come to open court or virtual, whichever the court will decide.
Since it's me reading, I think you can just listen online.
Virtual.
Yes, virtual.
That's okay.
Okay.
Your Lordship, perhaps on the suspects, are they supposed to be present or they can also appear?
It will be virtual, so if they want to hear what the court is saying, I see as if parties appear in council's chambers. The choice is yours.
The only danger is that it presupposes what directions you're going to give. Because if, for example, I don't know what you're going to do. Let me just finish. No, let me just finish. If it presupposes that
Gentlemen, if you do not maintain, tomorrow is 30th, eh? At 3, eh? Go on with the rest of the list.
Out of a hearing in the case of Republic versus Taita Yoma and 11 other police commanders. As you know, this is a historic case. It is being tried under the International Crimes Act, and we have spent the morning making representation. Among us here are advocates and members of staff of the following organizations: Amnesty International Kenya, the Law Society of Kenya, International Justice Mission, the Independent Medical and Legal Unit, Utu Wetu, and also the International Commission of Jurists. I believe I've got everybody. Okay. So we have just come out of court. There is no determination from the submissions that were made this morning by the Office of the Director of Public Prosecutions, the Independent Policing Oversight Authority, and several defense counsel for the over 60 victims of the police operation that took place during the general elections of 2017. Allow me to invite the Vice President, Maura Kabata, to give a quick overview of what happened this morning.
Good afternoon, members of the press. My name is Maura Kabata, LSK Vice President. We appeared before Justice Muigai today in the morning with the intention, or rather with the expectation, that we will take off with the plea taking for all the suspects who are arraigned in court today. However, once again, from the part of the Director of Public Prosecution, they sought to adjourn the plea taking and rather unconventionally also amend the charges. Now, on our part, together with, this is the Law Society, together with Amnesty, and together with Utu Wetu, including the LSK Kisumu chapter, we vehemently opposed that application for either amendment of the charges or adjournment. And because the file is bulky, the judge requested that she be allowed until tomorrow at 3 p.m., but virtually, so that she could be able to now canvass all the issues that have been raised and also give us a sense of direction as to where we are going. It should not be lost that the preceding judges who have handled these matters, this is Justice Kanyi Kimondo and Justice Lilian Mutende, have on repeated occasions ordered and directed that this plea be taken. And in fact, Justice Kimondo went ahead to even give a timeline of when the plea is to be taken. On our part, we are extremely disappointed with the decision by the Director of Public Prosecution to either adjourn the plea taking or amend the charges. You will realize that before, and this is the fourth adjournment, there have been many instances where the court has directed that the plea for all these top police officers be taken at a specific date. So the reason that we are getting from the DPP, and you will well note that the submissions from those who investigated these atrocities in Kisumu, which include atrocities such as rape, murder, forceful deportation of persons, were done by an independent office. This is IPOA. So when it comes to the part of the DPP, they already have the ingredients that are required to prosecute. But we are seeing an instance where they are not prosecuting. And you'll remember that even the court itself at one point shied away from putting a mark on the part of the DPP on whether this is being done by forces outside the DPP. And you'll remember that the DPP is an office which is supposed to be independent in the Constitution, that its mandate from the Constitution and authority is to operate without the influence or direction of any person. So we are hopeful that tomorrow we will still be here, and we invite you to come and document these proceedings because they are important for our sense of democratic health and for the sense of, importantly, the family and the victims. It should not be lost that Baby Pendo will be 10 years this year. I mean, we are talking about a human being. We are not talking about a bill in parliament or a policy that we are challenging. This time it is a human being who is not with us, a young baby who was 6 months old and is now completely taken off the face of the earth by activities that can be directed directly to members of the National Police Service. So allow me to invite Willis to also make a closure on this matter.
Thank you very much. I'm Willis Otieno, advocate for Utuetu, appearing for the victims in these proceedings. One thing that we must not focus on is that this case involves baby Pendo, a 6 months old baby who was clobbered on her head to death on her baby coat by police officers. This case is about accountability to the victims of atrocities that were committed in Kisumu, Nyalenda, Nyamasaria, Obunga, and Nyawita. And the police officers who are the command of the units that committed these atrocities, they deserve to have their date to answer in court for what their respective units did. The unfortunate thing that we must point out, some of the named suspects in this case have been promoted. They've been promoted since the atrocities took place. They are now holding senior positions in the National Police Service Commission as we speak. Number two, we must call out Renson Igonga, the DPP. If the DPP is not interested in prosecuting this case, then he owes Kenyans an explanation as to why he does not intend for plea taking to be done in this particular case. There is no day this matter has been deferred at the instance of the victims or at the instance of the courts. All the adjournments have now been, since the Justice Kimondo ruling, have been at the instance of the prosecution. The DPP has been coming to court that is not willing to have the 11 suspects take plea because one person is not present. That is a fallacy. People are charged in these courts every day with others not before court. Plea taking can take place at any stage of proceedings, and the DPP deserves and is particular instance, he is reluctant to have the 11 suspects to take plea just because one person is missing. And it's not enough for him to say or try to throw it to the courts and to say he wants to now amend the charge sheet. They have had that charge sheet now for more than 5 years. They have not acted on it. Now they're asking the court to give them more time. All this is a delaying tactic to deny the people of Kisumu, those who suffered from the atrocities committed in 2017 and 2018, their opportunity to face their tormentors or those who had responsibility of the units that committed their torments. Thank you.
Thank you very much. We will give a statement once the ruling is given tomorrow at 3 p.m. Thank you for following up today. It's good to see so many of you here, and I'm sure the family of baby Pendo